behalf of Jones Day, we would like to welcome you to Emerging Issues in Product Liability Litigation. Our program today is being presented as a webinar only. This program is scheduled to run from 2 p.m. to 3 p.m. Eastern Standard Time. If you're having difficulty hearing me, please check to make sure that you have the volume on your computer turned up all the way. If you have any other technical difficulties, contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you have not already downloaded a copy of the presentation materials and the CLE credit information sheet, you can do so from the Handouts tab on the left. Before we launch the live presentation, here is some CLE information. The presentation has been approved for CLE credit for attendees. The CLE credit information sheet in the Handouts tab provides you with the information regarding the available credit. Applications for CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of the webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you have not individually registered for this webinar, please do so immediately by emailing Nikki Sherrill at nsherill@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have only up to a minute to confirm participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged on for the entire presentation or segment. Otherwise, CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory to enter your bar number. If you cannot locate your bar numbers, please contact the Beacon Live Help Desk for assistance. You will be in a listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located on the lower left corner of your screen. We will attempt to answer those questions throughout the program. With the housekeeping out of the way, I will now turn it over to Stephanie Parker, Jones Day Business and Tort Litigation Practice Leader in Atlanta.
Thank you. Welcome to Jones Day's seminar on emerging issues in product liability litigation. We very much appreciate your attendance and your interest, and we know your time is valuable, so we're going to make sure that we succinctly cover all the key points that you need to know about these emerging issues. As you're going forward, if you have any questions or any follow-up comments that we'll do our best to address at the end, please type those in the Q&A part of your screen. And at the end, following all four of the presentations, I'll go back and ask the speakers to address as many of those as possible. So thank you again for attending, and I'm now going to turn over the program to our first speaker, Brian Murray.
Good afternoon, everybody, and again, my welcome to today's webinar. On the agenda for me is the Campbell Ewald versus Gomez decision recently decided by the U.S. Supreme Court. And what its import might be for those in the class action space who are trying to stop class actions literally before they begin. Now, what is Campbell Ewald about? This is a case that got argued back in the very first sitting back in October, but took until January to decide. And when it was granted, it was seen as a potential blockbuster, heralded by some as perhaps the end of class actions as we know them. Now, of course, we've heard that before with arbitration clauses and the like, and yet class actions continue to go on. They probably will after this, too. It turns out the decision was much more moderate in actual result as the defense lawyer saw it, or not, depending who you talk to, but you can make your own decision. So what happened? In the case, the issue was, does an unaccepted offer to satisfy the named plaintiff's individual claim, is that sufficient to render a case moot when the complaint seeks relief on behalf of the plaintiff and a class of persons similarly situated? In other words, when a plaintiff comes forward with a class action and you offer that person everything that she could possibly get in the way of damages, attorney's fees, costs, etc., does that moot that person's claim and with it the claims of the rest of a putative class? The short answer, we hold today that an unaccepted offer of settlement has no force. I could stop there, but of course I've got 10 more minutes and you need CLE, so I'll go into a little bit more detail. Here's the background of the case. Campbell Ewald was a nationwide advertising company hired by the Navy to do a multimedia campaign to attract recruits to the Navy. One prong of this campaign was to send text messages to young adults encouraging them to learn more about the Navy. The Navy said, let's do this, but only send them to people who've opted in to receive text messages from us, and unfortunately that didn't quite happen. So some plaintiffs' lawyers got involved. And they found a statute, of course, the Telephone Consumer Protection Act, which prohibits sending those messages and has monetary penalties, treble damages, etc. Their plaintiff, Jose Gomez, got one of these messages. He said he never consented to getting a message, and he was also 40-ish and had no interest in joining the Navy. And so as night follows day, the nationwide class action ensued. But the defendant, too, had creative lawyers, and before the deadline for filing a class certification motion passed, they made an offer of judgment to Gomez. They also made him a straight settlement offer on the side. And both of these included that they would pay the costs of the suit, no attorney's fees because they said the statute didn't provide for them, and treble damages for a total of $1,503. And also a stipulated injunction that they would follow the TCPA going forward. But they denied liability and denied that there were any grounds for an injunction despite agreeing to it. Gomez, for his part, said, forget it, I want to move forward with my class action, and the offer of judgment, by rule, expired 14 days after it was made and not accepted. So what happened next? The defendant's lawyers moved to dismiss the case for lack of jurisdiction, saying this is moot. The theory being they gave Gomez everything he could possibly have wanted, there's nothing left to litigate. And also, because they did so before he moved for class certification, they thought that meant the putative class claims were also moot. If you can't represent yourself, you certainly can't represent a class. How did the courts react? Well, the district court in the Central District of California said, you know, an offer of judgment does not render a plaintiff's claim moot, nor does it moot class claims. Why is that? Well, for the individual plaintiff hasn't gotten anything, it's just an offer of judgment. And as to class certification, even if you were to take out the individual plaintiff, a timely class certification motion would relate back to the filing of the complaint. So the class still could move forward. The Ninth Circuit, of course, affirmed, which brought the split to the Supreme Court. The Supreme Court granted certiorari and noted a vast split on this issue, ranging from the sublime to the absurd. For example, I live in the Seventh Circuit, where the rule prior to this case was you can cut off a plaintiff and cut off a class action so long as the plaintiff hasn't actually filed a class cert motion by the time you offer him judgment or her judgment. So what you would see here in state and federal court is you would be served with a complaint, and attached to the back of the complaint would be a class certification motion. Now, this is a joke in light of the Dukes versus Walmart case. They've had no time to develop evidence. They have no idea what's in a class certification motion. Nonetheless, one would be attached reciting the bare bones of what would be a class certification motion solely to make sure they didn't doubt. One of the more strange results, but certainly one of the results that fed into this split that convinced the Supreme Court to work this out once and for all. So what happened? Justice Ginsburg wrote for the majority, and she said, you know, Article 3 limits federal court jurisdiction to cases and controversies. Well, we all know that. And that requires an actual adversarial controversy. Mootness can end that, but it only happens when it's impossible for a court to grant any effectual relief whatsoever to a prevailing party. 3 terms ago, the court came up against this question in the Simzik case, but left it explicitly open as both parties agreed that the offer of judgment mooted the individual claim. In that case, Justice Kagan had written separately, she would have addressed this threshold issue and held that an unaccepted settlement offer is a legal nullity with no operative effect. In other words, you can't make a settlement offer and thereby moot out a claim if it's not accepted. In this majority, Justice Ginsburg, quote, now adopted that view, holding that Gomez's complaint was not effaced by Campbell's unaccepted offer to satisfy his individual claim. The court cited basic principles of contract law that a Rule 68 offer, once rejected, has no continuing efficacy, other than to cut off costs under the rule, of course. Interestingly, the court distinguished 3 1800 railroad taxes cases. Why does that matter? Well, in those cases, the defendant had not merely offered to pay, like an offer of judgment here, but had actually deposited the full amount demanded in a bank account in the state's name. Here, once the settlement offer expired, Gomez remained empty-handed. And because the individual claim was not mooted a fortiori, the class could proceed. Because while the class had no independent status before certification, Gomez still could pursue it since he had a live claim. Is there a silver lining here? Well, for defense lawyers, maybe. Back to the railroad cases. The court was careful to observe that the defendant only made an offer of judgment and made clear we need not and do not decide whether the result would be different if a defendant deposits the full amount of the plaintiff's individual claim in an account payable to the plaintiff, and the court then enters judgment for the plaintiff in that amount. Now, of course, in a case like this, there are separate opinions. Justice Thomas concurred in the judgment, and the Chief and Justice Alito dissented. Justice Thomas's concurrence basically said, I don't want to think about this as a Rule 68 offer of judgment case. I'd like to think about it in the context of common law history of tenders. The interesting twist here they work out mostly the same, except that in the common law history of tenders, a tender required an admission of liability. So you couldn't do, as the defendant had here, an offer to stipulate to an injunction but deny liability. Here with the tender, you'd have to admit liability. But he came out the same way because, again, he thought it was not something that mooted out the case. The Chief also dissented. His point was simply, as a practical matter, what are we doing here? Gomez was offered all the monetary and injunctive relief he wanted. There's nothing left for him to want other than a court to say he's right, and that's not a justiciable controversy. It's true, as he pointed out, the defendant hasn't actually paid up, but there's no question here that it can. And if there were a question, again, as the majority points out, and he may have shaped this part of the majority by writing this dissent, a deposit in a certified check with the court would really do it. To hold otherwise, he'd pointed out, puts the question of jurisdiction in the hands of the offeree. In other words, if I'm the plaintiff and I accept the offer of judgment, the case is over, no jurisdiction, it's moot. If I deny and say no thanks to the offer of judgment, then there's jurisdiction. Leaving jurisdiction up to a plaintiff seems really strange. Usually courts decide that. And finally, Justice Alito wrote separately to say, there's really no dispute here that the defendant would make good on its promise to pay. But if there were a dispute, he wouldn't find the case moot. And he pointed out the easiest ways to make sure a defendant will pay would be to actually pay, or if it's clear as here that you've got a giant company and a small payment involved, that's okay too. But if there's any doubt, maybe it wouldn't be moot after all. So what are the takeaways? As I said when we started, in many circuits, it used to be possible to pick off a class action with an offer of judgment to the named plaintiff before class certification was moved for, and sometimes even before the motion was filed. Now that's not so. But if you give over all of the money, not just make an offer of judgment, but give the money in an account payable to the plaintiff or give the money to a court who could then enter judgment for the plaintiff with the money, that might still be enough to pick off a plaintiff. While the court reserved the question, there seems every indication that a majority of the justices would go for that. Now, of course, keep in mind the usual rules apply. What would have to be deposited or made available would be the full relief. Costs, attorney's fees, if there's injunctive relief requested, the full value of that injunctive relief, etc. So in a lot of cases, this offer, or tender I should say, of money may still not make sense. It may just be too great of a sum to do up front. But in small cases where you might be able to make the case go away just by putting up a small sum of money rather than just making an offer of judgment, I think the teaching of this case is it's still potentially available out there and might be an effective way to cut off big litigation even before it starts. With that, I'd like to turn it over to my friend and partner in Washington, D.C., Tschida Beretsky. Shai?
Thanks, Brian. I'd like to talk about two class action cases that were argued in the November 2015 sitting, Spokeo versus Robbins and Tyson Foods versus Spokeo. In Spokeo, the question presented, I'll let you read the legalese on the screen. In essence, the question is, can the violation of a congressionally created right by itself constitute the injury that Article 3 requires in order to have standing? A brief refresher on Article 3 might help. Remember that Article 3 standing requires that the plaintiff, first of all, suffer an injury in fact, an injury that's concrete and particularized, and actual or imminent. Second, that the defendant have caused the injury. And third, that a court be able to redress the injury. Spokeo is specifically a case about the first of these requirements, the injury in fact requirement. In the early 1990s, in a case called Lujan, the Supreme Court made clear that Congress may confer standing by making a de facto injury legally cognizable. What do I mean by that? To give an example, religious discrimination in hiring is clearly an injury if you're denied a job because of your religion. It was not traditionally an injury that you could sue over. Congress changed that in Title VII and thereby elevated a de facto injury into a legally cognizable one, and there's no doubt that it had the power to do so. The question here is, can Congress confer standing on a party that hasn't suffered a de facto injury? That is, can Congress itself create the de facto injury? And that's the issue in Spokeo. The petitioner in the case is a company called Spokeo. It aggregates information about people that it posts online. And the respondent, Robbins, claims that Spokeo posted inaccurate information about him and thereby violated the Fair Credit Reporting Act. He didn't allege that he suffered any actual harm from the publication of this information. He wasn't, for example, turned down for a job or for credit as a result of the inaccurate posting. Nevertheless, the Fair Credit Reporting Act permitted him to bring a suit for statutory damages. The Ninth Circuit agreed that he could bring that suit, that the bare violation of his rights under the FCPA was an injury in fact, and the Supreme Court granted cert to decide. You might be asking, why does this matter? Let me give an example in terms of a product liability situation. Imagine the following facts. A company inadvertently allows a toxic chemical, kryptonite, to leak onto federal land. Thousands of people are exposed to that kryptonite before the leak is detected, but the exposure is so brief that none of these people could be injured by the kryptonite. They were exposed to it, but nothing bad actually happened to them. On these facts alone, none of these individuals suffered an actual injury, and they have no Article III standing to sue. Now imagine that Congress passes a statute, and that the statute was passed before the leak. The statute says there's an absolute right to be free of kryptonite exposure while on federal land. Anyone exposed to kryptonite may enforce this right in a private lawsuit. The emitting party shall be held strictly liable and made to pay the larger of actual damages or $50,000 per gallon emitted. Now does anybody have standing? And that's what Spokeo may tell us. The individuals who were exposed still haven't suffered any actual injury, but as a result of this statute, they would have a right to bring a suit for $50,000 per gallon emitted. So this has significant ramifications because it could drastically expand the ability of Congress to create private rights of action for individuals who could then act like private state AGs. Particularly, there's potential for class actions along those lines. And it would be particularly bad for business interests because these congressionally created private rights of action often arise in the consumer protection context, like, for example, the Fair Credit Reporting Act. In terms of takeaways from the oral argument, with all the usual caveats that it's hard to predict how a case is going to turn out based on the oral argument, the questions from the court appeared to be divided along traditional 5-4 ideological lines. Questions from Justices Kagan and Sotomayor suggested it was unlikely that they would rule for Spokeo, while questions from the Chief Justice and Justice Alito suggested it was unlikely that they would rule for Robbins. There did not appear to be a whole lot of appetite on the court, based on the questions, for holding that Congress can create injuries in fact out of whole cloth. Justice Kagan, for example, seemed to accept the principle that the de facto injury has to arise independent of a congressional statute. However, she did suggest that the disclosure of information at issue in this case is, without more, an injury in fact, even if, as I said, there are no tangible consequences like the denial of a job or the denial of credit that follows from it. If I had to predict, I would say that the real dispute in this case is going to turn on the definition of what is an injury in fact. That is, how concrete does the injury have to be in order for it to satisfy Article III standing? Is the mere disclosure of inaccurate information a de facto injury, even if nobody actually reads the information? And that's no small issue. As is often the case, a lot of observers think that this will turn out to be a 5-4 decision with Justice Kennedy as the ultimate deciding vote. The other case I'd like to talk about is Tyson Foods versus Spokeo. This case is easier to understand with a bit of background. The plaintiff in this case is Peg Spokeo, let's just call her Peg, and she brought a class action on behalf of workers at a pork processing plant in Iowa. She alleged violations of the Fair Labor Standards Act. That statute requires employers to pay overtime for work weeks in excess of 40 hours, and it requires employers to count toward that time certain pre- and post-employment activities like donning and doffing necessary work clothes. To compensate for the time spent donning and doffing those clothes, Tyson added 4 minutes per day to each employee's time. Peg alleged that wasn't enough, and to prove it, she produced evidence that, on average, it took longer than 4 minutes to put on and take off the clothing at issue. She then added that time to the recorded time worked by each employee, which brought some employees over the 40-hour figure at which overtime is required. She therefore alleged that Tyson violated the FLSA by failing to pay that overtime. The class was certified, a jury found in favor of the class, and the Eighth Circuit affirmed. Tyson then sought cert on 2 issues. Again, you can read the legalese on the screen. The first question is, Tyson argued that there were large variations in donning and doffing time between particular workers, so that the averages that the lower court relied on were inaccurate as applied to particular employees. And the question is that proper? Can you have liability based on those sorts of statistical techniques? The second and related question, Tyson argued that, in fact, many employees didn't work more than 40 hours, and that the averages used by the class obscured this. Those who didn't work more than 40 hours suffered no injury and therefore would have no Article III standing, and this therefore presented a second question, whether a class can be certified where some of the class members have not suffered any injury at all. Rule 23b3, of course, requires that a class action says that a class action may be maintained if Rule 23a requirements are satisfied and if the court finds that the questions of law or fact common to the class members predominate over any questions affecting only individual members. With respect to the first question presented, Tyson argued to the Supreme Court that the class members' use of averages resulted in a trial by formula. The phrase trial by formula comes from the Supreme Court's earlier decision in Walmart versus Dukes, and it refers to a process where liability and damages are determined by statistical modeling without further individualized proceedings. In Dukes, the Supreme Court generally condemned that kind of approach to trying a class action. The Eighth Circuit said here this was not trial by formula because the process actually was individualized. The average data that was used was then applied to each individual class member by adding the average donning and doffing time to the actual recorded time worked. So as the case was teed up to the court, it looked like this would be an opportunity for the court to elaborate about what it said in Dukes in generally condemning the use of statistical information to try class cases in this way. After oral argument, though, it looks like we may not get much elaboration on what it means to conduct a trial by formula and when it's permissible because of a Supreme Court precedent specific to the FLSA context called Anderson versus Mount Clemens Pottery Company. And in that case, the questions at argument suggested that the justices might read that case to find that in the FLSA context, statistical evidence can be sufficient to make out a claim, and if the court ultimately decided Tyson Foods on that basis, it would likely not have the kind of impact that people initially expected for other types of class actions. With respect to the second question presented, certifying classes with uninjured class members, this is potentially even the bigger blockbuster issue in this case if the court were to reach it. And there are 2 potential problems related to classes that contain uninjured members. One is predominance. If the question of whether there is even an injury will come up for too many class members, then that member-specific question will predominate over the common questions, and class certification is improper under Rule 23b3. The other problem with this sort of certification is Article III standing. Courts are divided on the question of whether every class member needs to have been injured and have standing, or whether it's sufficient for just one class member to have standing. That standing issue in particular makes Tyson a potential blockbuster. If all class members must have standing, it's a lot harder to bring a class action. Imagine trying to prove that each of tens of thousands of class members suffered an actual injury that gives rise to standing. In many instances, that would be very difficult, and class plaintiffs would instead need to carefully define classes so that they are potentially much smaller and necessarily only include those individuals who suffered an actual injury. That said, as with Spokeo, it seemed unlikely, based on the oral argument, that the court would really want to take on this bigger issue. The Justices' questions at oral argument suggested at least a couple of ways that they might be able to avoid this. The respondent argued that the court should dismiss the second question as improvidently granted because Tyson allegedly, according to the respondent, shifted its focus in its merits brief in the Supreme Court in a way that was pretty different from what was argued in the cert petition. Alternatively, if the court agrees with the respondent that the Mount Clemens case created an evidentiary standard that is unique to FLSA cases, then everyone who collects on an FLSA claim will necessarily have proven an injury, namely the withholding of overtime pay. And the question of whether there are any uninjured members in this FLSA class would simply not arise. By definition, they will all have been injured. And so Tyson Foods, I think, is a case that was very closely watched when it was granted because of these potential blockbuster issues. But I think based on the oral argument, if I had to predict, the court is more likely to reach a narrow holding that is based on the FLSA and doesn't have the sorts of implications that people initially expected that the case might have. With that, I'll turn over the program to Jose Isasi in our Chicago office, who's going to speak about Batson challenges.
Hi, good afternoon, everyone. Thank you for joining us. My name is Jose Isasi, and I'm going to turn to a topic now that is near and dear to the hearts of lawyers who, like me, represent product manufacturer defendants in jury trials. That is jury selection. We are likely 3 to 4 weeks away from a decision in this case, Foster versus Chapman. And which way the court goes on that and how broad a decision they render could profoundly impact the ability of trial lawyers to exercise preemptory strikes, and we'll talk about that. It's a critical tool for trial lawyers and will impact how they prepare for jury selection. So in addition to talking briefly for a moment about jury selection, preemptory strikes, so that everyone understands the context in which this decision will come down, we'll also talk for a moment about this case, Batson versus Kentucky, which many of us have heard of perhaps, and the rule that it established, and then Foster itself and the implications of any decision that may come down. Now, if you are like me, you know the iconic film 12 Angry Men. This is one of various versions of it. This scene is from the initial vote in 12 Angry Men when 11 of the 12 jurors all vote to convict a criminal defendant, and one, Henry Fonda, whose back is to you there, is the sole holdout. Now, in my experience, not every jury is as thoughtful necessarily as the one that we saw in 12 Angry Men. But what is realistic about the portrayal of that jury is the impact that one individual juror can have on the deliberations. And so the ability to find such a juror who might be, because of their life experience or other aspects of them, predisposed against your client and be able to remove them from the potential jury pool is critical. Now, the issue of preemptive strikes comes up because there's sometimes a difference between what the judge's goal is and what trial counsel's goal is during jury selection. The process, which could be a subject of its own presentation on voir dire, is designed to expose the biases and prejudices and personal views of potential jurors. But after you go through that process, you're left with a pool of potential jurors who could be seated, who weren't automatically disqualified and were not what is called struck for cause. The standard for striking someone for cause varies, but a common one is that the juror must agree to keep an open mind, evaluate the evidence fairly, be impartial, follow the law instructed by the judge. But judges apply that standard differently, and they are not generally interested in letting jurors out for little or no reason as they see it. And so sometimes jurors who you think have cause, lowercase c, don't quite qualify in the judge's mind for cause. And that's where preemptory challenges come in. They've been around for hundreds of years. They come out of the English legal tradition, been an important part of the American legal tradition for some time. And it allows each party a finite number of strikes, which you can exercise on anyone for virtually any reason. And the reasons that are prohibited really first emerge in the case of Batson. Now, the Batson case involved an African-American defendant and the exercise by the prosecutor of strikes of all African-American jurors. And the rule that was announced in that case was that you could not exercise preemptive strikes based upon a racial basis. You cannot strike because someone is a member of a particular race. The difference being prior to that, while that was the rule, to prove prejudice in the use of a preemptory strike, you had to show the overall system of that prosecutor's office, prejudiced or biased against minority jurors. Here, the burden was changed, and you began to look specifically at the facts of that particular jury selection, and you could use just those facts to establish that that strikes were being exercised to remove members of the defendant's own race. And at that point, in what is now a familiar to us who practice in trial courts, three-part test, once you showed that, the burden shifted to the party that was exercising the strikes to provide what's called a race-neutral explanation, a reason other than the fact that the prospective juror was black in this case, to support the reason why the preemptory was exercised. And if they can do that, the last part of the test was, well, the challenging party has to demonstrate that that explanation is just a pretext. And the persuasiveness of the reason was according to the court, critical in making that determination. Now, at the same time, though, Batson reaffirmed the important role that preemptory challenges play in trials. So there were a number of interesting decisions that came down concerning Batson. They extended the Batson rule to civil trials. That was in 1991. And then Batson was extended in 1994 to include exclusion based on gender, the JEB case. Interestingly enough, that's a case where men were being excluded from the jury. The same rationale, same equal protection rationale was utilized in those cases. And then there's been at least one federal circuit court in the last couple of years that has extended that rule to sexual orientation. Well, that brings us to Foster. Foster is a murder trial back in 1987, and the timing is important because that was shortly after the original Batson decision came down. And in that case, you had an African-American defendant and a white victim. The lawyers for the defendant argued at all levels that there was a practice within that prosecutor's office of keeping black jurors from being seated. And consistent with that, the defendant and his attorneys raised Batson challenges to the strikes that were exercised in that case. The way this process worked was after you got past that initial stage where the questions were going to be asked by the lawyers, there was a weekend. The prosecutor's office did research, came in, and on a Monday conducted their examination of the witnesses, or the jurors, and struck jurors. The result was all the prospective jurors that could have been seated that were African American were struck preemptorily. The lawyers for the defendant, and he was convicted, raised on post-trial and then throughout the appellate process Batson challenges, and they were all denied. But then, 20 years later, under Georgia's Open Records Act, the lawyers for Foster got access to the notes of the prosecutor from the deliberation, and they were interesting. And in the case of Foster, they were game-changing. I've pulled a couple of the items from the record here so you can see. On the left is a chart. This is similar to what many of us would have, which is during voir dire or voir dire, depending on where in the country you are, a chart showing the names of the different jurors and where you would take notes on them, different things that you learn about them. And on the right was a record that was found in the prosecutor's file and had been prepared prior to that process where the prosecutor got to ask questions. And what you need to know about this is if you look on the left, you can kind of see some green highlighting. All the African American jurors were highlighted in green. The list essentially was race-coded. Other records showed that the prosecutors had ranked the prospective black jurors against each other as opposed to sort of as part of the whole pool. And there's a notation in the records by one member of the team that it's a quote, if it comes down to having to pick one of the black jurors, and then they suggest one of them. The record on the right, what you should know is that the first 5 people who are listed on the definite no's are all African American. They were the African Americans that were struck, and they were struck in that order. So there is race permeated the notes here. And what Mr. Foster's attorneys did was they claimed, based on this new evidence, which they took to court, it showed that these jurors had been struck not for the various reasons that had been given by the prosecutor, a laundry list of different things that he didn't like about them, but because they were African American. And they pointed out that because they'd gone through this process, some of the prosecutor's reasons had changed over time, and some of them turned out to be inconsistent. I think probably the most important inconsistency that the court latched onto was this issue that one of the jurors on the definite no list, the prosecutor had indicated, she was almost seated. It was just one answer she gave that I didn't like, when there was contemporaneous information that they'd already decided not to seat her. So the state relied, as often does, on the standard of review and said that there were explanations for all of this, and that all these arguments had been heard, and there was no clear evidence, which was the standard that was required. But during the oral argument on this, which occurred back in November, the justices were not, they were troubled by the inconsistencies between the prosecutor's justifications for strikes and the notes. And probably the best argument that the state came up with was that all this race coding and the references to race within the records was because the lawyers for Mr. Foster had indicated prior to jury selection that they intended to raise a Batson challenge, and so the prosecutor was simply getting prepared to know which jurors he would need to defend any strikes if he made. The problem with that, as Justice Sotomayor pointed out, was that justification came up for the first and only time 20 years later in the brief in front of the Supreme Court. So it carried less weight. And because of the procedural posture that this case has come up to the Supreme Court, that is that there have been multiple Batson decisions made, and they've been on the merits rather than the subsequent ones being that on some procedural grounds. It appears pretty clear that there's going to be a merits decision from the Supreme Court. It won't be a procedural decision, and that decision could be a couple different ways. It could be a ruling that the defendant failed to demonstrate by clear evidence that the lower court's decision was erroneous. I will tell you that, having looked with the same caveats, it's difficult to predict anything based on an argument transcript. But if you look at the way some of these justices have voted in the past on these issues and the argument, you could see that Justices Kagan, Sotomayor, and Breyer were pretty incredulous about the record here and any idea that race didn't play a role, whereas Justice Scalia was equally skeptical that there was any reason to reverse, and Justice Thomas, who voted with Justice Scalia against the extension of Batson to gender in the JEB case, was typically silent during argument. But the conclusions that the court could reach here could result in a broad rule or a narrow ruling. Even a narrow holding would arm challenging lawyers with new grounds to go after any exercise of peremptory challenge for anyone based on gender, based on race. But an announcement of a new standard, a modification of the Batson test, could result in trial courts becoming more skeptical and also recognizing that their decisions on these rulings are being granted less deference. The Supreme Court has nothing more than the cold record in front of it. It didn't have a chance to assess the credibility of the prosecutor or anything like that, and nevertheless they will be supplanting their judgment for the trial courts. That's never going to leave a trial court judge comfortable, and she may feel it is necessary to apply more scrutiny to those race-neutral reasons for a challenge. And with that, I will turn over the presentation to my partner, Cheryl Reisman in New York.
Hi, everyone. It's Cheryl. I am going to address with you this afternoon binding arbitration clauses and whether there's something different about warranties that preclude or prohibit the use of binding arbitration clauses in warranties. And just to set the stage before we begin and get into details, arbitration clauses with class action waivers are a pretty effective way for companies to minimize class action exposure. And our focus today is going to be on using arbitration clauses in warranties and whether those are enforceable. But really the enforceability of those agreements is important because it's the class action waiver within that clause that provides the protection against class actions. And so we'll start with some background on 3 recent Supreme Court cases that address and make clear that courts must enforce otherwise valid arbitration agreements even if they contain a class action waiver. So then the question becomes, is there something different about including a binding arbitration clause in warranties that's different than other consumer contracts? And the FTC and federal courts of appeals have taken conflicting positions on that. So at the end of my presentation, you will still be left in great suspense. But starting with the Supreme Court cases, there have been 3 recent cases up on your screen now, AT&T and Mobility versus Concepcion, American Express via Italian Colors Restaurant, and DirecTV versus Imburgia that pretty much established the law of the land on class action waivers in arbitration clauses. And really the starting point for determining whether a court will enforce an arbitration clause or agreement is the Federal Arbitration Act. And the court has made clear that the FAA has a liberal federal policy favoring arbitration, and it requires courts to enforce arbitration agreements according to their terms. And on the 3 cases you see here before you, and many that have come before it, the Supreme Court has read the Federal Arbitration Act to establish a presumption in favor of the enforceability of contractual arbitration agreements. And in terms of these 3 recent decisions, the Supreme Court has addressed or really put the nail in the coffin on the issue as to whether there is something different about a class action waiver within an arbitration clause or an arbitration agreement that would overcome that presumption. And it has affirmed, reaffirmed, and then confirmed again that the federal policy in favor of enforcing agreements to arbitrate applies even when the arbitration clause prohibits class arbitration. And in the first case, AT&T Mobility versus Concepcion, the court held that the Federal Arbitration Act preempts the California Discovery Bank Rule. And that rule held that class action waivers in themselves were unconscionable and thus unenforceable. In American Express versus Italian Colors, the court held that the FAA's, the Federal Arbitration Act's command to enforce arbitration agreements trumps any interest ensuring the prosecution of low-value claims, which we know is one of the plaintiff's main arguments for pursuing class actions is that individuals would not pursue these actions on an individual basis because the recovery doesn't merit the expense of litigating. And most recently in DirecTV versus Imburgia, the Supreme Court again confirmed the supremacy of the Federal Arbitration Act. And the interesting thing about Imburgia was that it was Breyer, Justice Breyer, writing the majority opinion in the case while he had dissented in AT&T Mobility and American Express via Italian Colors. But again, the court put the nail in the coffin with that final decision. So the key is that in order for companies to use arbitration clauses with class action waivers, to limit their class action exposures, the claims at issue must be subject to arbitration. They must be arbitrable. So the question is, are warranty claims subject to binding arbitration? To answer that question, we need to start with the Magnuson-Moss Warranty Act, which was a statute enacted about 40 years ago. And the purpose of the statute was basically to make warranties on consumer products more readily understandable, transparent to consumers to prevent deception in marketing of consumer products. And to go back to Shai's slide of the pig, it's basically wanting to ensure that consumers don't get a pig in a poke. Who must comply with the Magnuson-Moss Warranty Act? Manufacturers of consumer products, any manufacturer of a consumer product who offers a warranty in writing that either promises the product is defect-free or promises to remedy a defect or both, must comply with the Act. And basically the Act imposes various content and format requirements, but mainly it's making sure that everything is spelled out clearly and conspicuously in an easy-to-read document. And as far as the issues we are talking about today and the ability to use arbitration clauses containing class action waivers, the two key issues when it comes to class actions are that the Act provides a federal cause of action for state law warranty claims. And more importantly for plaintiffs' lawyers is the consumer can recover attorney fees under the Act. So what are the provisions that really are at the center of the debate when we're discussing whether warranties present a different situation and somehow preclude the use of arbitration clauses and thus class action waivers? And the key provisions of the Act that come into play are the ones that, that you see here that address informal dispute settlement mechanisms. And the Act establishes a policy encouraging warrantors to establish procedures for informal dispute settlement. And of course, then it requires that those procedures be spelled out very clearly in the warranty. But the point is that Congress wanted to establish quick and fair procedures to allow for resolution of warranty claims. And in order to encourage warrantors to create these dispute resolution systems, if a warrantor actually establishes an informal dispute settlement mechanism, the consumer must resort to that mechanism before filing any civil action under the Act. So the question is, what qualifies as an informal dispute settlement mechanism? How is it defined? Well, interestingly, it's not. And in fact, arbitration, the word arbitration, is not mentioned or found anywhere in the text of the entire statute. So going back to the question, does the Act impact the ability to require arbitration of warranty claims? Can warranty claims be subject to arbitration? There's absolutely nothing that we see in the Act that says arbitration clauses should be treated any differently. And in fact, most courts and lawyers and clients who refer to arbitration would not refer to it as informal. Alternative dispute resolution maybe, but informal, it's hard to see how you would view it as an informal dispute mechanism. Having said that, I'll put my personal views and our views on where this will end up aside for a moment, and let's look at what the quote-unquote authorities have said in terms of the use of arbitration clauses and warranties. Well, the FTC, the protector of American consumers, charged with implementing and enforcing the Act, says that the Act actually prohibits binding arbitration clauses and written warranties. And there have been only two federal courts of appeals, or actually two federal courts of appeals who still have standing decisions, the 5th and the 11th Circuits, that have addressed the issue, and they have both held that binding arbitration clauses are permitted for in warranties. And of course, holding you all in suspense, the Supreme Court has not yet addressed the issue, and states and other federal district courts are split on the issue. So how does the FTC come to their position? So while the Act itself doesn't define informal dispute settlement mechanisms or the procedures, it does empower the FTC to establish rules setting forth the minimum requirements for any informal dispute settlement procedure. And in fact, the FTC has done just that, and one of them, the FTC Rule 703, outlines the minimum requirements for informal dispute settlement mechanisms. And for purposes of this rule, mechanism means an informal dispute settlement procedure which is incorporated into the terms of the warranty. And importantly, the FTC has established a rule that the decisions of the mechanism shall not be legally binding on any person. And if the rule goes on to say that any mechanism established must comply with Rule 703. So what does that mean? Well, according to the FTC's interpretations, and recognize that the interpretations represent the Commission's views, they're basically advisory in nature, but the FTC interprets the provisions that you see, the decision shall not be legally binding, to prohibit warrantors from including binding arbitration clauses in their contracts. And in fact, just recently in July 2015, they issued their final action and reaffirmed their long-held view that the Act disfavors and authorizes the Commission to prohibit mandatory binding arbitration and warranties. What do the courts say? Well, they don't exactly agree with the FTC. So I mentioned two courts of appeals that have addressed the issue and have standing decisions. The Ninth Circuit actually addressed the issue as well, but has withdrawn its opinion. The Ninth Circuit found actually consistent and deferred to the FTC interpretation, but that decision has been withdrawn. The two federal appellate court decisions that are standing are in the Fifth and 11th Circuit, both upholding the binding arbitration of warranty claims. And interestingly, the slide notes that the federal district courts and other circuits are divided on the issue, but it's actually pretty important to look at the fact that the most recent district court opinions to address the issue in the past several years, and actually at least for the past 5 years, find no prohibition to binding arbitration, and in fact often cite to the quote-unquote well-reasoned opinions of the Fifth and 11th Circuits. So what are those well-reasoned opinions of the Fifth and 11th Circuits, and how did they get there? Well, we know that the Federal Arbitration Act establishes a clear federal policy favoring arbitration, and the Supreme Court has shouted that from the hilltops. We also know that from Supreme Court under McMahon and other decisions, both before and after it, that the FAA's mandate requiring enforcement of arbitration agreement applies to statutory claims unless overridden by a clear contrary congressional command. And in fact, every case that's come before the Supreme Court involving a statutory right that does not explicitly preclude arbitration, the Supreme Court has upheld the application of the Federal Arbitration Act and the Arbitration Clause. So the question is whether the Federal Arbitration Act's mandate has been overridden by a contrary congressional command in the Magnuson-Moss Warranty Act. And it's the party opposing the presumption that bears the burden of demonstrating, as McMahon lays out, whether Congress has evinced an intention to preclude a waiver of judicial remedies for the statutory rights at issue. That is, has Congress evinced an intent to preclude binding arbitration and warranties? And the simple answer is no. And both the Fifth and 11th Circuits in Walton and Davis come to the same answer with similar reasoning, although slightly differing interpretations. And in order to come to their opinions and their findings, they look at the McMahon factors that you see, the statutory text, legislative history, and the purpose of the statutes. Does arbitration conflict with the purpose of the Magnuson-Moss Warranty Act? And on all three counts, the answer is no, that the court has not evinced the intention. The statutory text does not include any prohibition against arbitration. And in fact, I gave you some previews to what this issue is, that not only does it not mention it, but informal dispute mechanisms does not typically refer, courts nor lawyers typically refer to informal dispute mechanisms or arbitrations as informal dispute mechanisms. And then the next question is whether the interpretation of the FTC is entitled to Chevron deference. And Chevron deference is, of course, the deference that is given to agencies' interpretations of a statute that administers where Congress has not already spoken and where the agency's interpretation is reasonable. So the question is, has Congress spoken? Fifth Circuit found that Congress has directly spoken that it has not precluded arbitration. The 11th Circuit found slightly differently, but on Chevron deference, they both came out to the same place, which is that the FTC's interpretation is not reasonable and not entitled to deference. Where have the states come out? The states come out, the majority of the state courts that have addressed the issue have also found that the Act's claims are subject to binding arbitration. And the Alabama, Illinois, Texas, and Michigan Supreme Courts have addressed the issue. And I started Virginia here on the list because Virginia, actually, you'll see on the next slide, also has, it's a circuit court opinion, and their circuit court's opinion is going both ways. Certain state Supreme Courts have found that the Act prohibits binding arbitration, but the majority, as you saw, permit binding arbitration. So to sum this up, one of the interesting things to note is that as the FTC issued its final action in July, a dissenting statement by one of the commissioners was a pretty telling statement, and in fact pretty much sees the writing on the walls. The courts have sent a clear signal that the Commission's position that MagnusonMoss Warranty Act prohibits binding arbitration is no longer supportable. 2 federal appellate courts have held that the Magnuson-Moss Warranty Act does not prohibit binding arbitration, and there is no circuit court precedent upholding the Commission's interpretation of the Magnuson-Moss Warranty Act. And in fact, as she notes, the Supreme Court has indicated its strong preference for arbitration, which is where we started. So our prediction is if this comes before the court will decide along the lines of the 5th and 11th Circuit's decisions. And with that, I turn it back to Stephanie Parker.
Thank you. We have almost 5 minutes left, so we have time for some questions. I'm going to start with Jose. Here's the question to you. What advice would you give to lawyers regarding their notes during jury selection? And should lawyers be more careful post-Chapman?
That's a great question. I can see, depending on how how that decision comes down, that trial judges may be a little more emboldened to hold more robust Batson hearings. For private litigants, it's unlikely that you get the same kind of wholesale disclosure of your notes that happened in Chapman, just because in most states your notes as a private litigant aren't state records under Open Meetings Act. But I can see conduct by the trial lawyer putting those notes at issue. So my practice would be perhaps changed, modified a little bit, in that I would ensure that if I went up to the podium to make my preemptory strikes, that nothing on the sheet of paper that I was holding had any either racial or gender-specific references to it. So that if for some reason the document that I was relying on as I made the strikes was somehow put at issue, there'd be nothing on that would reveal either race or gender playing a role.
Okay. I have another question in our short time we have left. I'm going to address this one to Shai. Here's this question. One of the cases that you discussed, Tyson, has been described as a blockbuster by the commentators, but from your comments, it sounds like it actually might decide very little. Is that accurate, and why did the court even grant cert in the case?
I think that is accurate. I think most likely the court will decide very little. As for why the court granted cert in the case, I think those of us who practice before the Supreme Court wish that it would give us more of an explanation of why it grants or denies cases, but it doesn't really. I think what may have happened here is sometimes an issue that looks unimportant at the outset ends up being decisive. It may well be that the justices reviewed the Eighth Circuit's opinion, saw that it was an FLSA case, didn't think that that was a particular obstacle to deciding broader issues, so they should grant anyway. But as it turns out, the FLSA specific features of the case may well be dispositive of the case. Or maybe they were aware that this was a very FLSA-specific issue, and they thought that the FLSA issue alone warranted a grant. There's just no way to know because the court doesn't give us much, if any, explanation about its cert process in deciding which cases to grant.
Great. Thank you. I'm sorry we're right up to our time limit. Thank you all so much for attending. And if any of you have any follow-up questions or if you'd like to discuss any of these issues by telephone or in more detail, please do contact us. Thank you again for your attendance. And with that, we are concluding.
Thanks again to our presenters, and a special thanks to everyone in the audience. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. Goodbye.